All right, so good evening. My name is Casey Williams. I am the new chair of the Ethics Commission. The time is 5:36, I believe, and so we're going to call this meeting to order at this time. The city attorney has verified that we have a quorum. We're missing only one commissioner, Alexandra Serra. To the best of our knowledge, there isn't anybody else that's missing at this time. Is that correct? No? Okay, so the city has provided us with an agenda that was prepared in advance of this meeting, and so we'd like to go through the order of business as it's assigned on this agenda. As your chair, it's my responsibility to marshal us through what's been planned for today. So our first order of business has been completed, and that was to call this meeting to order. Our second order of business is public comment. So at this time, I would like to open the floor for any members of the public that would like to address this commission for public comment. Is there any public comment at this time? Being that the commission meeting is almost empty of members of the public, we're going to move forward with our next item on the agenda, and that's the approval of minutes from February the 1st. You all have been provided a copy of the minutes. May I entertain a motion to approve the minutes?
So moved.
So the minutes have been moved and seconded.
Second.
Thank you, Commissioner Grasslheim and Commissioner Kern. Then I'd like to entertain a motion to call the question or to approve the minutes. All those in favor of approving the minutes say aye.
Aye.
All those opposed? The ayes have it, and so now the minutes have been approved. Our next item is item number 4. It's a review of the February 1st, 2023 determination of the Ethics Review Commission in the matter of Representative Kennedy. I'd like to ask our city attorney how this item should be addressed by the commission. Is there a member of the commission that's supposed to discuss it, or what is normally done?
So the language of the item is simply for review of the document. The interim chair did review it and sign off on it, as you can see in your packet. There is no action for the commission to take here today. Most of you were present for the hearing last week. It's a recording and a basic recitation of what happened at the committee meeting, what the proceeding was like, the findings of fact, there's conclusions, and then the opinion of the commission. If any of the members of the commission have any questions, we can certainly address those, but it's not intended to be an action item. It's simply for you all to get a final copy and see it as being signed and issued.
All right. For the public's benefit, I'd like to remind them that I, as the chair, had recused myself because of a possible perception of a conflict of interest with the person that was the complainant on that action. But I do have a question just in general about how those issues are resolved, and I'd like to address this question for the city attorney. The burden of production for determining whether or not a violation has taken place, is that clear and convincing, or is it a preponderance of evidence standard?
You're testing my knowledge of the standard of proof. I need to pull it from the ordinance. It is clear on the ordinance, but I can't tell you off the top of my head here today.
What I recall, Commissioner Chair, what I recall is that Mr. Garza explained to us it was clear and convincing.
Okay.
That's what I recall.
It's actually under the findings of fact. I'm glad you brought that up. It is under the findings of fact. It is under the preponderance of the evidence did not support a finding. It's on page 2 of the Ethics Review Commission determination under findings of fact. It's a preponderance of the evidence.
So that was a question that I had after reviewing the document, because a preponderance standard was used, but the conclusion acknowledges a clear and convincing standard for people that are not attorneys. When you are looking at burdens of production or the amount of proof you have to show, if you can imagine a book, and I happen to have one that I'm just reading at my leisure. This is how I learned this in law school. This is by the Prince Harry. If you have 50%, and then one page more, like 51%, you've met your burden of proof for a preponderance of evidence. So usually that's the standard that we use to sue people. In immigration court, it's a standard that we use to approve certain applications for relief. It's basically the lowest burden of production that's used to win cases in court. When you do clear and convincing, it's really more of like 75% of this imaginary book that we're using. That's the burden that we use to separate parents from their children in most states. That's a higher burden of proof. And then many of us that are not attorneys are familiar with the phrase beyond a reasonable doubt, which is basically 99% of this book, minus like a page. Beyond a reasonable doubt is what we use to deprive people of their life or their liberty, which is why when you are criminally prosecuted, it is so difficult. So this is the reason why I asked our city attorney about burdens of production, because we need to make sure that we're consistent with what the law requires, and that the decision that was made by the commission follows what the ordinance requires, that it's not just language, but that it's certain legally recognized burdens of production that have to be met when people raise these claims. So that's why I asked the question, do we have an answer for that from the ordinance?
It is the same standard of review here, that it is the preponderance of the evidence. That's why it's in the determination of the Ethics Commission.
Mr. Chairman, I seem to recall, but I don't have it right here with me, but I seem to recall, like Commissioner Momsen, that it was a clear and convincing, which is a lesser, and I think it's several places it says that. I can't put my finger on it right now, but I do recall that it was clear and convincing and not necessarily a preponderance of the evidence. So it's the lesser of the burdens, if you will. But maybe we can clarify it later.
Sure, I just think that it's important to be precise, and forgive me for having to correct you, Commissioner, but clear and convincing is more than a preponderance of evidence. And so this is an important burden of proof discussion that we have to have, because as an ethics commission, we also have an ethical duty to apply the correct legal standard. In court, when people apply the incorrect legal standard to make a determination, that could be considered a reversible error, or it could be a basis to overturn a judge's decision. So that's the only reason why I asked. Not that I'm suggesting that a decision should be overturned here. I just want to make sure that the commission is informed about which burden of production is used in order to make a decision.
Maybe in the presentation that Mr. Garza made, I think it went through that process, and you're right, higher standard of clear and convincing, and I recall him mentioning that. So there may be a conflict somewhere, or misunderstanding, or maybe the section might use a different.
So maybe I'm not following the conversation. Is the concern that the findings of fact as a preponderance of the evidence is incorrect based on what was decided?
The conversation is what burden of proof was used for the findings of fact, because in the decision, it says the commission hearing the matter so finds by clear and convincing evidence. That's a higher burden of proof than a preponderance of evidence. Although within the analysis of the findings of fact, the analysis applies a preponderance of evidence standard. So the question for the city attorney.
I'm sorry, I missed, where are you reading the clear and convincing part? Am I missing it?
Yes, it's on the last page. It says opinion
So,
of the commission.
so what could have been, and it could be a typographical error that I didn't catch this, but the preponderance of the evidence, and then it's by clear and convincing. But let me just confirm it now, in
Okay.
terms of what it's not coming up on my search.
So while you look for that, another legal question that I have for the city attorney is what happens when a finding of fact may have a misstatement? Let's assume that clear and convincing is not the correct standard. what is the process to amend the decision so that it's consistent with the law?
So it is a clear and convincing statement, so it's the second, the first revision that needs to be, there needs to be a revision to the findings of fact to read as a clear and convincing.
Does that revision require the commission to reevaluate the evidence that's in the record?
No, it's simply a mistake in writing the findings of fact, in doing preponderance of the evidence, and then the findings of fact at the opinion stage where it says clear and convincing.
So I'm going to support your analysis based on the fact that if it was the intent of the commission, minus myself, to use a clear and convincing standard, even if a preponderance of evidence standard was incorrectly stated, they still used the higher standard to determine whether or not a violation had taken place. But the opinion needs to be corrected. So
Correct. So
what
we will-
action can we take to make sure that it's consistent?
So I will correct the findings of fact, paragraph 1, to ensure that it reads by clear and convincing.
Does that require a vote from the commission, or how is that action ameliorated?
Well, I mean, it didn't affect the outcome of the manner in which the commission handled the meeting. This is simply a record of the proceeding and the final order. So I will clarify and change this language to say clear and convincing. It didn't change the process or the evidence or what the commission was required to do on the day of the hearing.
Okay, so as your chair, and I'm hoping that I'm not in a conflicted situation, but I would like to make sure that there isn't any objection to the city attorney making that amendment. Are there any objections from the commission?
No objection.
Okay.
I'd like to add something. You decided it on a clear and convincing standard, that the preponderance of the evidence standard would be subsumed within that anyway.
That's
So,
right.
so there's really nothing that needs to be redone.
Okay, so then,
And
Mr. Commissioner, if I may, so if it helps, 292-200 disposition of the charter in section D says, if after hearing the issues, the Ethics Review Commission determines through clear and convincing evidence that a violation of this chapter has occurred, then the Ethics Review Commission may issue one of the following sanctions.
so that was helpful, because that's where we find our burden of production. So we've now discussed it. No commissioners had any issues with the amendment to the record. It's a ministerial act that doesn't affect the outcome. Is that correct, Mrs. Neiman?
yes, that's correct.
All right. Is there any discussion on this item before we move on to the next item?
I'm curious because I wasn't able to attend the meeting. I did read all the minutes. I saw that, that Mark dissented and was the sole dissenter, I guess, on the decision. Is that accurate?
To the best of my knowledge, it is, but because I was recused, I was not a part of any of the meeting. I was physically in another location.
Yeah, not that it changes anything, but just for my own edification, I'd like to know what was the basis of his dissent.
It wasn't
Because that was
really,
not in the minutes.
Commissioner Kern, it wasn't really a dissent. It was that he introduced a motion, and there was no second to that motion, and then a subsequent motion was introduced and seconded and voted on. So, I
Okay.
mean, maybe that is a dissent, but.
So it's procedural, not substantive?
Well, it was substantive to him, I believe.
It-
I mean,
Okay.
he
Well-
seemed to introduce his motion in good faith, but
see.
no one seconded his motion. It did not go any further.
Commissioner
It died.
Hernandez?
Yeah, Mr. Kern, I think that objection you're interpreting is his motion that he initially made to find a violation to which there was no second. Having died because of a lack of a second, a new motion was made and seconded and adopted. There was no violation.
So there was no discussion of the actual reasons for his motion then? Is that accurate?
I think that would be the correct thing because there was no
Okay.
second.
Well, thank you for clarifying that. I just want to say, even though I wasn't able to attend the meeting, I read everything. I read it very carefully. I thought the commission decided the matter correctly. And I applaud you all for taking 5 hours to do that. I asked Martha if I needed to bring my toothbrush to the meeting tonight, but I've been reassured this meeting is probably not going to last that long.
And I am committed to this purpose for us to use our time expeditiously. So is there any other discussion on item number 4? Seeing how there is no further discussion, I'd like to move on to the next item. That's item number 5, which is a review of the February 17th, 2023 advisory panel opinions regarding Representative Kennedy participating in or voting on any issue involving ASM Global DBA Destination El Paso Live et al. Managed facilities. We, just for a bit of history and to make it brief, appointed an advisory panel. Ms. Grashland was a part of the original advisory panel, but she ethically chose to recuse herself, notating a possible perception of a conflict of interest. And so we asked Commissioner Walker to replace her temporarily for the specific issue, which he did. And then the commission advisory panel reviewed the materials and then made a decision. So this is the first time that this commission has had an advisory panel opinion done in almost 2 years. And so I had asked the city attorney, what is the process for the introduction of an advisory panel decision. It's my understanding that the commission doesn't vote on the advisory panel decision, that it's just presented before the commission. Now, Vice Chair, you have the most amount of time on this commission. Would you like to discuss your experience about what the commission has done in the past with advisory opinions?
I don't think there's much to discuss. You know, the commission did not meet much because of the pandemic. We only had a few Zoom meetings that I recall. And this is the second in-person meeting that I'm aware of. So I don't think there's a whole lot to discuss. I don't recall any previous advisory opinions during my term. I'm actually in the middle of my second term now, have about 10 months left. I don't recall any advisory opinions. I might be forgetting something, but I don't think there have been any. I will say I thought this one, the subcommittee or subcommission that worked on it did a good job.
Right. Well, we want to make sure that we set a precedent for how these issues are handled, because we want the commission to be accessible for the purpose that it was intended. But the city attorney had verified that there is no language in our ethics commission code that requires us to take any additional action beyond the panel issuing its opinion. Is that correct, Mrs. Neiman?
That's correct.
All right, so is there any discussion about this item or the decision that was issued by the advisory panel? No?
Excuse me, Mr. Chairman, as an addendum to what you just said, I think the decision is based on what the commission had decided on. So it's not that the commission goes independently and writes its own opinion, but it follows if you will, the directive of the commission that they take.
Well, let's do this, because the public may not have had an opportunity to read the decision themselves. Is there a member among our advisory panel that issued the decision that would like to explain briefly what their decision was? Mr. Walker is not here, so this is a decision that is going to take place either between you, Commissioner Hernandez, or Commissioner Momsen. Which one among you would like to explain what conclusion you reached? Ms. Momsen? Commissioner Momsen.
Chair Williams, thank you for recognizing me. Our subcommittee conclusion was, and I'm reading from it, is that we have no evidence from Mr. Kennedy's previous employment, consulting, and financial history that would preclude Mr. Kennedy from voting on items related to ASM Global. There were two separate advisory opinions that City Council Member Representative Kennedy requested. That was one. Then the second one was regarding the multipurpose center, is that correct? Okay, unless, and the conclusion that we, the subcommittee, arrived at is that and I do want to note that we were unanimous in this conclusion, correct, Commissioner Hernandez?
You are correct.
And we concluded, unless the facts as they were presented at the February 1st, 2023 Ethics Commission hearing change, at this time, there is nothing in Mr. Kennedy's previous employment, consulting, and financial history that would require his recusal under Article 2 Standards of Conduct in regards to the multipurpose center.
Okay, so thank you for reading us the decision that you all reached. I will say, and this is just me speaking as a colleague who happens to be licensed in another state. I'm licensed in New Mexico. But I do know that most states have rules about conflicts of loyalty. And certainly the Texas Disciplinary Rules of Professional Conduct 1.06F4 discusses that. It mentions that lawyers who may have their own interests and responsibilities to others, if it creates a conflict in that professional capacity, then the client may have the right to ask the attorney to recuse themselves. So I would just say that very cautiously, I understand that we're governed by a separate set of rules, but it's always, in my opinion, a little more tenuous for an attorney that represents people and who is also a member of a different body that may potentially be at odds with one another, to not recognize that maybe there may be a conflict of interest in the future involving their duty of loyalty to their client. But that's beyond the scope of this advisory opinion. But I think the public needs to know that this commission is bound by the rules that we have. And so we follow the ones that are present in our code, but certainly there are other forums where other issues may be challenged.
Mr. Chair, can I make one administrative
Yes,
comment since
Mr.
we're on
Weston.
this subject matter? It just so happened that the last issue that was presented to the entire commission was related to the issue that went in for an advisory opinion as well.
Mhm.
There may be times where there is a request for an advisory opinion that the whole commission will not hear. And so, I mean, I know that I'm probably stating the obvious, but that very well could happen. There could be something that, you know, wasn't going to be brought forward to the entire commission. Someone wanted to, you know, it could be a city council representative, it could be someone who else is appointed that wants an opinion before they carry out something and do something to make sure they're going to be on solid ground. Now, the advisory panel can also hear that and then opt not to make that decision and bring it back to the entire ethics commission.
Mhm.
So just because you have delegated the responsibility to commission members as an advisory panel, if they hear that and feel they can't render a proper decision, or they don't feel that they should as an advisory panel, I think it should be much more broadly looked at by the commission. They have the ability to do that as well. I hope that makes sense.
It does make sense. Did you want to say something about that, Mrs. Neiman?
No, I would just, if you think about the purpose of the Ethics Commission, it's to encourage people to behave ethically and to follow the city's rules, policies. But it gives you the opportunity to come and ask before I go do something. So it's not intended to be a gotcha game where now I'm going to go file an ethics complaint against you. It's supposed to encourage our officers and our employees to have the ability to do that kind of due diligence and ask this commission, you know, whatever the scenario might be, before I go do something, that they get the opportunity to hear it before an advisory panel. So it's intended to also encourage openness and transparency in their dealings, right, on an everyday basis. So it's not just for officers of the organization, but it is also for employees of the organization that can submit a request for an advisory opinion.
Did you want to say something, Commissioner Hernandez?
Yes, Mr. Chairman. I believe that the advisory opinion that the city attorney presented to us, as I guess as an example, at the first meeting, is exactly the kind of issue that we're discussing, where I believe Representative Hernandez wanted to find out if there was a conflict because she was involved, I guess, in a relationship with a specific person who I guess is a lobbyist or something to that effect. And so that's what you're talking about. Am I
Correct.
correct?
That's correct.
So I have to say, I understand that people need to be able to approach the commission and be able to get opinions, and sometimes they may want those things to be done in confidence. But there is an educational purpose for a public meeting. And when people make use of an advisory panel and are able to discuss the boundaries of where their ethics are bound and where they may fall short of what's expected of them, that helps the general public and the other officers who may not have encountered that situation but now are aware that this may be a situation where they may need to seek guidance. It's not necessarily the Ethics Commission's purpose to act as an attorney for them. Certainly they have access to the city attorney's office also if they have questions about whether something may be unethical in their dealings. Is that correct, Mrs. Neiman?
Yes, that is provided to the members of council and the city manager and his employees.
And so those conversations would be bound by your rules of professional conduct of being confidential, is that correct?
Right, depending on the set of circumstances.
So in a situation where a person may feel like they need an opinion about something that's sensitive that maybe they don't want to have discussed publicly, they would be able to approach your office to discuss that with you in confidence as a member of city council or a public officer, is that correct?
Yes, that's correct.
Okay, but in a situation where they ask for an official advisory panel position, where they want to make
Right.
the situation vetted through this commission, then certainly our responsibility to be able to share that information publicly actually acts as a safeguard for them. Because as they often do, they say, I sought the opinion of the Ethics Commission first, and they have cleared this proposed action, provided that it is the way that I described it. So that's an additional layer of protection. Am I understanding that correctly?
Yes, and that's actually the language, not exactly the language, but when a person receives an advisory opinion, as long as they act in accordance with the advice provided to them, they can use it to prevent an ethics complaint from moving forward against them if they can show that they followed the advisory opinion's recommendations.
And so and now this is just a ministerial conversation, in a situation where someone seeks a advisory panel opinion, who decides whether or not it can be kept confidential or whether it will be discussed with the chair or be placed on the agenda? Who makes that decision?
On placing the advisory opinion on the agenda?
That's correct. Or just knowing that one was sought?
So advisory opinions are brought before the whole board after they're issued. So it's no different from what we've done here today.
Uh-huh.
Those items are placed on the future Ethics Commission agenda for the entire commission to review and see. And then the documents are posted on the city's website and are attached to the agenda, so the public has access to those records.
Right, and I want the public to know that as chair of this commission, I would like to do as much as possible to make our work transparent. One, because it helps the public to know we're working. Two, because the opinions that our commission issues is informative and serves an educational purpose in helping other people to understand how to marshal their way through our rules. And finally, it's just good, it's good practice to let the public know that there are elected officials or public officials that are seeking guidance from a commission that was designed to help them to choose ethical decisions in their dealings. I have a question about whether or not, Mrs. Neiman, the commission's charter or the rules that govern our commission have any provision for members of individual commissioners if they disagree with an advisory panel. Is there any history or are there any rules about how those issues are resolved?
During my tenure, I haven't seen, this is the only other advisory opinion that has been issued besides Representative Hernandez's request. The Ethics Commission doesn't discuss that specific scenario. So what the Ethics Commission, the Ethics Ordinance does allow is that if the advisory panel chooses to not issue an opinion, then it comes to the entire board. But there is no discussion about having individual members of individual members of the commission disagreeing with the issuance of the advisory opinion.
Okay, well, that now goes beyond the scope of our agenda today, but I think that there may be an opportunity for us to meet and to discuss areas of opportunity for making our advisory panel process even more efficient and accessible. So is there any other discussion on item number 5?
Mr. Chair, if I may. I think Mrs. Neiman answered my question already, but I just wanted to clarify. So the decisions that the advisory panel made last month, if the person that requested the opinion operates within the boundaries of the decision, then that decision now sets a precedent for them moving forward. So the advisory commission, or the ethics review commission, or an advisory panel wouldn't necessarily have to reconvene again if a complaint was made. Is that correct?
That's correct.
Thank you, ma'am.
All right, any other discussion? No? All right, so item number 6 was kind of already discussed also by Commissioner Momsen. It's a review of the February 17, 2023 advisory panel opinion regarding Representative Kennedy participating in or voting on any issue involving the MPC. But I would like to give Commissioner Momsen an opportunity if she'd like to add anything in addition to what she's already described. No? Then is there any further discussion on item number 6? No? Seeing how there is no discussion, let's move on to our next item. That's item number 7, proposed amendments to the ethics ordinance for jurisdiction of municipal candidates and political committees. Before we ask Mrs. Neiman to explain what she has provided for our review, just a very brief history. We as a commission asked the city attorney to include political candidates to be subject to the jurisdiction of this ethics commission, which just, in my opinion, makes sense because it doesn't make sense to have elected officials held to our ethics, and the people that run against them are free to just do whatever they want, as long as the Texas Ethics Commission chooses not to accept their cases, which many times they don't. Mrs. Neiman was kind enough to provide us, at the request of Commissioner Grisham, a kind of red line proposal, and I noticed that political action committees were included there also, which I think is a great idea. But Mrs. Neiman, would you like to please explain what you provided for the commission to review today?
So at the last meeting of this commission, I went through a PowerPoint presentation that explained the basis for why we were proposing this. The commission requested that I come back with a red line. So you all have the red line in your packet, so you can see the specific provisions that are being proposed. So there's 2 sections of the ethics ordinance that we are proposing to be amended. It's 2.92.120, which is the jurisdiction of the commission, and then we would add, after the word officers, and I'll read the entire provision. It currently reads, the Ethics Review Commission shall have jurisdiction to review alleged violations of Article 2, which is the standards of conduct of this chapter by officers. And we would add the phrase candidates, comma, and/or political committees that occurred within 2 years of the complaint being filed. And then we would make the exact same change under section 2.92160, which is filing a complaint. And then the provision in section B, any resident of the city, including a member of the Ethics Review Commission or natural person conducting business with the city who believes that an officer, comma, candidate, comma, and/or political committee has violated Article 2 of this chapter may file a sworn complaint with the city clerk. So those are the 2 provisions that we are proposing would include the new persons that would be subject to the regulations of the Ethics Commission, and then the commission would have jurisdiction to hear ethics complaints against.
Thank you.
For purposes of the definition of candidate, the definition is already included in the ethics ordinance. And candidate, it means a candidate for an elected office of the city of El Paso. All references to candidate shall include the candidate's principal campaign committee, whether or not the candidate acts as a treasurer for reporting purposes, Candidates shall not include a city official or employee who is a candidate of any other elected office. So, as has been common in the past, we have current members of council who are terming out, but then they would decide to run for a different elected office that is not a municipal. So they could run for the county or the state or the federal or whatever other. The jurisdiction of the commission would not extend to that candidate's actions during the campaign for a different office that is outside of the municipal world. So it's only for a candidate in a municipal office.
Thank you. Commissioner Hernandez?
Mr. Chairman, on the second part, the political committees, I heard you say a while ago, political action committees. That's a very different political animal, PAC, the PAC. So is the political committee to be understood to be a PAC or not?
That's a
So
good
let
question.
me read you the definition, because the definition is
Thank
also
you.
included in our ethics ordinance already.
Thank you.
It's political committee, and it means a specific purpose political committee or a general purpose political committee, as those terms are defined in the Texas Elections Code. So it's both specific purpose or general purpose.
That includes PACs if you look at the definition under the Texas Ethics Code.
It's
So
the
they've-
Texas Elections Code.
Election code, I'm sorry. So they've incorporated that language.
Should we use the broader language, political action committee, or not?
I would tend to tell you no, simply because we use the definition that is defined already in the ethics ordinance. I guess for purposes of the commission, and maybe you can clarify the significance of the difference for you in terms of the jurisdiction that's being provided to the commission in this amendment.
What do you think is the difference between the two terms, is what she's asking you, Commissioner Hernandez?
Well, I just want consistency so that when we talk about political committee, that we understand that either it is or is not a political action committee.
Okay.
I understand that from Ms. Neiman that it does include it. Am I correct, Ms. Neiman?
It's correct. It means both a specific purpose, political committee, or a general purpose, political committee, which I think the basic vernacular that we use is a political action committee, but under
Election code.
the elections code, there's specific differences, but we're encompassing all of it, and we don't call it a political action committee, we just call it a political committee,
Mhm. So
which could include both under the Texas Elections Code.
I've actually created political committees in the past, and I've been a part of political committees in the past, and people are supposed to register their organization with the state of Texas, and then they're also supposed to provide information about the money that they raise for political purposes. So if you have an organization that is raising money for a political purpose, you're supposed to register as a political committee. Not everybody does it, and they should. And that's the Texas Ethics Commission's work to come after those people. But the city has not done that in the past, which is why we're adding this language. Yes, it's true that generally people have heard the term political action committee, but in Texas, they use the term political committee, which is describing the same thing.
Right.
Is there another question or any other?
I have a question. I noticed there's a 2-year statute of limitations, or at least it kind of functions that way, in the jurisdictions section, but in the filing a complaint section, I'm not seeing any limitations. So I have a question for Ms. Neiman. Is there a limitation somewhere else on how long a resident of the city has to file a complaint?
It would be the same, sir. It's the jurisdiction only lasts for 2 years.
Okay.
So you could not, a person could not file a complaint past the 2-year statute of limitations.
Well, I'm reading this a little different. What it says is that the commission loses jurisdiction 2 years after the complaint is filed. I think that's what that says, but it doesn't really say anything about how long people have to file a complaint. And if that's not somewhere else, I think we should add that.
So for purposes of the way that we administer the code, we would not accept a complaint where the allegation took place past the 2-year statute of limitations. And that's something that we vet, and then the city clerk's office vets as well, so that if the allegation has passed the 2 years, it would not be a valid complaint that would move to the commission.
Is that written somewhere?
No, that's the way we interpret the jurisdiction of the commission.
Okay. Is there any issue with adding it here to 292.160B?
I'm reading the filing of the complaint portion of the,
Yeah, that they would have 2 years to file a complaint after the incident, whatever they're complaining about occurred.
right, I'm reading that specific provision to see if it is already,
Seems to me, I thought we had that in when we did
the last revision.
the check.
Let me look.
So we asked the city attorney's clerk to provide you, I asked for a binder, but we got a folder, which is fine. So if you're looking for the language of the ordinance that governs our commission, that's been provided in the second folder for you. And the reason why I asked for that was I just think it's best practices. I understand that all of you are very sophisticated people that can find laws on your own. But when I served on the Civil Service Commission, I thought it was helpful that they created a binder that had everything that we could encounter so that we didn't have to fumble through our phones or through our laptops to find answers. We would have them readily available, and you can call me old-fashioned, but I just think it's easier to look things up when it's printed on paper. I'm very analog that way. So use it for what it's worth. If you don't want to use it, that's fine, but that's why that's been provided for you, is because I requested it, and I think it helped the commissioners in the Civil Service Commission. I'm very grateful to Ms. Lozano for helping us out with that request.
Commissioner Kern, in
Yeah.
section 2.92.170, complaint review, section B, it's
What page is that on? In the complete
let me
ordinance?
look at that, let me look at that document. I'm reading it off of my
170, it's on page 22.
point, yeah,
Page
170.
22?
Yes,
Okay. Is that where the statute is?
This is, the version that we gave you is the ordinance. This is the codified version of the ordinance that exists in our code as it was approved by council. So you're reading off of page 12? Is that what you,
22.
I'm sorry,
And
22?
it's 2.92.170.
Yeah. It's just easier on my screen, but I want to make sure that I'm on the same page with you all. So if you look at section B, within 21 days,
170?
page 22 of 27,
160.
it's 170. It's the complaint review process of the, once a complaint is received, it is filed with the city clerk's office, and then they do a cursory review that ensures that it complies with the requirements of the ethics ordinance, and then it is forwarded to the city attorney's office, and then under section B, and it's actually on the top page of page 23, so you'll have to, there you go. It says, number 1, dismiss the complaint because it falls outside of the Ethics Review Commission's jurisdiction. So under the process by which a complaint is reviewed through the city clerk's office and through the city attorney's office, we are giving the authority to dismiss any complaint that is filed past the 2-year statute of limitations. So a person is not prohibited directly under the ethics ordinance from submitting an ethics complaint that is past the 2-year statute of limitations. They can submit it, and then we would review it, and then review it for purposes of ensuring, check the box, it's within the last 2 years, and the commission can review it. And if it falls outside of that, then the requirement is that I notify the complainant that the matter is dismissed because it's outside of the 2-year statute of limitations. There's the process is codified.
Right, so Vice Chair, is it your recommendation that they?
Well, here's how I view it, you know, having been an attorney for almost 40 years. Actually, my law school 40th reunion is coming up, so it has been 40 years. People will litigate this issue if it's ambiguous, and in my view, it's ambiguous. And so why not just have a clear statement in here that it's a 2-year statute of limitations, period? Then there's nothing to litigate because there's no ambiguity.
Commissioner Hernandez is
Yeah,
next, and we'll have you. Go
Go,
ahead.
Mr. Bray, go
Oh,
ahead.
okay, thank you. Well, I'm just going to follow up with that a little bit. To me, and I'm not an attorney, not 40 years, not even one day. But one of the things that frustrates me when I look at things like filling out my tax form, and I'm trying to get some information, and then you're referred from here to here to here, and it's like this circle you keep chasing to get the information you need to do this correctly. So if we are saying that we're okay with putting the 2-year statute of limitation under the jurisdiction paragraph, when an average citizen looking at the city code to see, how do I file a complaint? They're gonna look at the complaint, filing a complaint. And I think it would be helpful for an average citizen who's not an attorney to see here that violated an article of this chapter that's within 2 years. So they see that statute of limitations defined in the filing the complaint section as well. That's just my
That's a good
personal
point.
Thank you, Commissioner Hernandez.
Thank you, Mr. Chairman. I think if I understand Mr. Kern's comment is that in the first part, the jurisdiction, 1.20, after the red line political committee, that the next phrase or that occurred within 2 years of the complaint being filed be lifted and added to the .160 at the end of that sentence, strike the period after clerk, and add that occurred within 2 years of the complaint being filed. Am I correct, Mr. Kern?
Yeah, that's exactly what I'm
And for what it's
suggesting.
worth, I think it goes the extra mile, but it does address what Mr. Bray pointed out. Perhaps a person that's a layperson doesn't understand the difference between the jurisdiction and the ability to file a complaint will only get reinforced that if you file a complaint and this is outside the 2-year, that you're not going to be, it is not going to be valid, which is the same thing that the jurisdiction section says, and it clears up any ambiguity.
Okay, Commissioner Momsen? I mean, I don't see a problem with us making it redundant. It just,
I just need the repetition of where you are requesting that we drop it in.
we need to entertain a motion for that. Did you want to make a motion about where you want to put that?
Sure.
Vice Chair?
Well, I think it's already been pretty well stated, but I'll restate it. I think we should add to the end of section 292.160, the section that is entitled Filing a Complaint, a provision that provides for a 2-year statute of limitations. And the easiest way to do that, I think, is lift the language from the first section of 292.120 and just add to the very end there. So it would read something like, candidate and or political committee has violated Article 2 of this chapter may file a sworn complaint with the city clerk within 2 years of the alleged violation taking place.
Yeah, so I'll drop that language in at filing the complaint under section A, which
So-
the city employee has violated.
City Attorney, we'd like to vote on that issue, though, for the record.
No, of course, I'm just repeating so that I understand what the direction is of the commission.
Thank you, Mrs. Neiman. All right, so there's been a motion that's been made. Is there a second?
Second.
Okay, second by Commissioner Hernandez. All those in favor of the amendment proposed by our Vice Chair, Commissioner Kern, say aye.
Aye.
All those opposed? So the vote is unanimous, and as your chair, I'd like to ask the city attorney to please help us make that proposed amendment, and we'll call a meeting so that we can read the red line language at the next meeting that we'll schedule for next month. Did you, Commissioner Bray?
Yes, and if we're finished with that portion, Ben, before we move on to the next item, one of the things that I had a question about, I noticed in the agenda and also in her description, Attorney Neiman mentioned that this is for municipal elections, right? So if someone is a candidate for a municipal position, and yet the word municipal is not in these recommendations here, it just says candidate, and that might get to Mr. Kern's point again about a little bit of ambiguity.
Are you, is there any discussion about what Commissioner Bray has raised about the ambiguity of not specifying the jurisdiction to limit it to just municipal candidates in this section?
There's a definition section at the beginning of the ordinance, and so it defines candidate, means a candidate for an elected office of the city of El Paso.
Yeah, I thought that was pretty clear also.
Okay.
So that's our discussion. Is there more discussion about the question that was raised by Commissioner Bray? No, thank you, Commissioner Grashheim. So then, Commissioner Momsen.
Yes, my question, Ms. Neiman, is this change that would now apply to candidates or political committees, what would be the power of penalty over those individuals if we were to find that a candidate or a political committee violated the Ethics Commission? I'm unclear on what the next step would be, because on page 26 of the ethics ordinance, the current penalty is that a copy of the letter of our finding would be put in the person's permanent record. It doesn't say that, but I have to say that because it's funny. In their employment file. And we don't have an employment file for a candidate or a political committee. So I'm not understanding what impact we will have on these individuals or entities.
You know, before you answer, Mrs. Neiman, it's my understanding from our last presentation that we have the power to fine individuals that are in violation of the Ethics Commission. Am I incorrect in remembering that?
Yes, that's correct.
And so where a remedy that's been administratively acknowledged by Commissioner Momsen is certainly a remedy, for those that don't work for the city, a fine is something that we can assess as a body, is that correct?
Mm-hmm.
But the language seems to be missing from the ordinance.
Correct.
And so that looks like.
Or at least we're in that section.
Right, because when we look at page 26, and now I'm very grateful that Ms. Lozano helped us print this out for us, that language is not there. And so we need to add that. Would you like to make a motion so that we can consider adding language like that? I just don't think it needs to be very complicated. We should just have the power to fine.
And what is the scope of the fine?
The fine is a penalty for being found in violation. It's a.
But the dollar amount?
It wouldn't be allowed to be greater than $500 because of our misdemeanor ability under state law.
I'm sorry, Mr. Ryan is,
Thank you, Mr. Chair.
yes, sir.
Yeah, I think my only question with the fine is who is it payable to and what are those funds used for once the fine is paid?
It's my understanding that those fines have been assessed and then they're paid to the city. Is that correct?
That's correct.
Mrs. Neiman?
Yes, they're deposited in the city's
And is that
accounts.
for like a general obligation use or is that towards a certain program or some type of municipal maintenance?
That's a good
like
question.
if
for
there's
the-
any fines,
Fines
everything
go
goes to
into
road
the
funds.
city's general
Yeah.
fund unless they are designated by law, by statute or ordinance into a special revenue fund.
Right, which this wouldn't be, it would be a general fine.
Thank you.
So then I think you've raised a very important issue. How do we find people if it's not in our code, right? Did you want to raise a motion to propose language where we can amend the ordinance to include the assessment of a fine not to exceed $500?
If that is what is currently applicable to the office holders, yes.
So current office holders don't have fines though. So the issue is that you issue letters of admonition. There's 3 steps and that you can read through what the,
So
right, there's
we're
3
looking-
types. There's notification, admonition, and reprimand. And then there's removal of office for like a very severe. So what I would recommend is that you let me go back. We've benchmarked this issue and I don't have the information in front of me. We benchmarked what other cities do and we can come back with a scheme that I could show you in terms of what other cities have proposed in this specific area.
That's a good idea. Commissioner Hernandez?
Thank you, Mr. Chairman. Just as information for the commissioners, about a month ago, the Texas Ethics Commission issued a letter of violation to a representative here in El Paso that got defeated in the November election, and assessed a $1,000 penalty. The reason for bringing that up is I have that decision, but we may look to that entity and their procedures to how they go about assessing and the amount. And I guess what I'm just saying is that we ought to look in that area as Ms. Neiman pointed out, to see what other cities, and in this case, what the Texas Ethics Commission does.
I think that's a good idea. I wonder if it would be possible, as your chair, working with the city, see if we could bring in a member of the Texas Ethics Commission to talk to us about that. But I think that what our city attorney, Mrs. Neiman, has proposed about her researching what other cities have done and then getting back to us with the report about what has been done in the past, so that we can use that to inform a motion to amend this ordinance, it's a smart way to handle the issue. And I agree with you, Mr. Commissioner.
Mr. Chairman, if it's okay with the chair, I could bring copies of that decision that they made at the Texas Ethics Commission, and it goes through the process they went through it, and that might help us in finding a way of doing something in our code.
As your chair, I can add your materials to the agenda that we have, what we will make for the next month. So what I'll do is I'll just ask you to send that to Mrs. Lozano, and then we'll put it on the agenda. I think that's smart. Frankly, I was surprised that the Texas Ethics Commission took action because in the past, they refused to get involved in city elections. And so I'm interested to see what they said in that decision. But regardless, it's informative. So as chair of this commission, Mrs. Neiman, may I ask you to please prepare information for us about what other cities have done in terms of assessing fees, and then we'll table this issue until we can get to our next meeting after we've heard your presentation about that. Is that okay?
On the decision that the Texas Ethics Commission would you want me to bring it to you or to Ms. Lozano, or?
You can just send it to Mrs. Lozano.
Got it.
And then she always contacts me and lets me know what is being put together on the agenda.
Wonderful, thank you.
All right, you're welcome. Did Commissioner Momsen?
Yes, my next question is, if we were to find a candidate or a political action committee, and a political action committee isn't a person, but if we were to find that person, a candidate, and the person just didn't pay the fine, as many people don't pay their fines, then what? I'm not clear on what the next step will be against that person. Clearly, it would be, are we making this a violation of a city ordinance and therefore a criminal violation? So that the next, if they were not to pay the fine, then the judges could issue a capias warrant? Or are we making it a civil violation? And in that case, what is the next step on a civil violation?
Yeah, we would need to go back and look at what other cities do in that sense as well, because the ability of a municipality to issue a fine does have ramifications when they're left pending.
And I'm just not clear, is it just gonna hang out there?
I don't think so, and I'll tell you why. The Texas Ethics Commission makes those violations misdemeanors. It is a criminal offense. So there is teeth available in a process, and I don't think that this commission should be afraid to put in place a process that makes what we do matter to people. I don't think that this is a nebulous issue where we ask for a fine and then people don't pay it and it doesn't go anywhere. I think we can investigate and take steps so that it does have some bite to it, and so that it has some corrective power behind it, unless it's your concern, Commissioner Momsen, that you don't believe that the Ethics Commission for the city should entertain those kinds of powers as far as holding people accountable.
No, that's not what I'm saying, respectfully. What I'm saying is, I don't know what the next step is after that. After hypothetically, we have we'll say a person, because I see a whole other problem with the political committees, because that's not a person. So say we have a person and a candidate, and we issue a fine against that person. and the person just goes, I'm not going to pay that fine. What's our next, what is the city's next step in that? And I haven't heard what that next step is.
Well, I think we can get that answer at the next
Okay.
meeting, and to lead into that, it would be to refer the issue out to the law enforcement, and then they can issue a KBS and.
But
they
if
can-
it's civil,
Right.
if
so
it's
it depends-
criminal,
It depends on what the jurisdiction of the
Right.
commission is granted, because as a municipality, when we issue fines, they're considered misdemeanors, and then we collect, whether we collect through a warrant, or you collect through a civil process where we file a collection and say you owe the city
right,
X amount of money, right? Which is not normal in terms of misdemeanors, right? There's usually a warrant, and issues are brought to a head in that sense. But we would need to go back and look to see what additional language we would put in that section. There are other provisions that I could cross-reference, in other sections of our code for not paying your fees, but
Okay.
it's something that we would need to cross-reference to ensure that it's all tidied up.
Well, I'm glad that these questions have been asked, because
Mhm.
you're
Yeah,
right. we
they're
need to-
good, they're good questions. We'll make sure that the research is done. So not only will we look at the best practices, but I agree that there has to be, it has to go not just to the point of the fine itself, but like what punitively can be done if someone decides to disregard the overall
I
decision.
will say just one thing before I get to you, Mr. Woodcraft. With the Texas Ethics Commission, it's my understanding that it's the treasurer of the political committee who's held accountable. So that's how they enforce action, is that person can be criminally liable for not following their rules for filing filings and for doing what is required of them by the law. So even if you have a political committee that's lots of people, the treasurer is the one who's responsible, and usually that's the person who steps up and gets things done. Mr. Woodcraft.
Thank you, Mr. Chair. So I agree with Commissioner Momsen. I think a fine is feasible. I think it's suitable. I'm concerned about the enforceability of that fine. So I agree with her concern there. My only other concern is if we come back to this next month. So being a new commissioner to the commission, I did go back and watch the videos from the previous meetings, just kind of get caught up to speed. And I believe this was on the agenda for the last meeting as well. So my next concern would be, we bring it up next month, we find something else we need clarification on, we table it for the following month, and how long do we draw that out? So I'm curious, Mr. Chair, if we're only looking at administrative changes to what's here in front of us now, from an ambiguity perspective, is there a way that we can go ahead and approve that and then come back and look at the issues that we have concerns with? So we're not
Yes.
holding up this process, or do we need to do it collectively at the next meeting and potentially the following?
No. So Commissioner Woodcraft, this commission hasn't met for 2 years. And this is the first opportunity we've had to meet in person in a long time. And so when we brought this issue up before the city attorney, we all agreed that this was a major area of opportunity. Is it necessary for us to correct every defect that we find as we work our way through this process before we ask city council? No. Is that something that the commission did in the past? Yes, they did try to do kind of an omnibus, and they did a lot of very important changes that helped to bring the code together into one uniform statute. And so it's still our responsibility as trustees of this process to continue to make improvements, because that's just our responsibility as commissioners. So if at the next meeting, this commission feels like they want to vote on sending what recommendations we have now to city council, I highly recommend that, because I agree with you. I don't think that we should wait months and months and months until we feel like we've answered every question to ask city council to consider to do things. And I don't think that city council would be bothered by us asking them to make decisions about piecemeal positions with our ordinance, as long as it's not creating conflicts as we go along. So if it's your recommendation that we entertain a motion, for example, to just send the recommendations that we made for candidates and for political committees now to city council, you can do that. But as your chair would say, that some of the issues that Commissioner Momsen raised about enforcement are things that logically make sense to include with a proposal like that before we send it to city council. And that's just my own political judgment. But if there are other commissioners who feel otherwise, I understand it's just my responsibility to entertain those motions and then also to let you know what would be the best strategy to get these things changed and done.
If Commissioner Woodcraft's suggestion is a motion, I second it. And I'll explain why. I've been involved with other things like this, and it turns into kind of a perpetual motion machine, you know, where every time you meet again, you think of something else, and then it can take months, I mean, even years, to make changes to ordinances when you start going down that road.
Okay.
And I think we've accomplished something tonight. I think it sounds like we're all in agreement about the candidates and or political committee's language to add that. We voted on my suggestion to add within 2 years of the alleged violation taking place. We approved that. So we now have something that we could finalize, and I think we should.
Is that
Be-
sure?
Because if I could, let me finish.
Sorry.
I think Commissioner Momsen's suggestions were very good. I also think that's a big discussion.
Okay.
There's a lot of research that needs to be done on that. I'm not even sure we'll be ready to do that at our next meeting with that language, but it's important. But that's a big discussion
All right.
that she brought up.
Thank you very much, Vice Chair. Is that your motion, Commissioner Woodcraft?
Mr. Chair, before I make that decision, I would have one question for the city attorney. So, ma'am, if we were to make the motion to push this forward with the administrative changes that we've discussed, and I think we all agree upon, is it appropriate that we either ask or present something to city council that says with a to be published for an enforceability of the political committees?
From a practical perspective, what I would hate to have happen is you approve this and then we're working on the fines portion and we get a complaint filed against the political action committee or a candidate, and then it comes before the commission and you all can't do anything against if it rises to that level. So for purposes of not piecemealing the entire regulatory structure, I think that what we can do is come back pretty quickly here and show you the options that other cities institute, and then provide you a more robust amendment. And I really appreciate the amount of work that the commission is willing to put into this, but I would hate for you all to, and I understand why you're doing it, but what we can do is go back and do a more thorough, like, run through of where else in the regulatory scheme do these things need to exist so that it's thoroughly vetted, and then we come back with a wholehearted amendment in regards to the candidates and political action committees that includes a similar structure for our employees or our elected officials, right? What would happen to our elected officials? There has to be a parallel path for political action committees as well as candidates.
Okay.
Otherwise, we would run into trouble without having the whole regulatory scheme in place.
Commissioner Momsen.
I'd like to explain to the commission that I was the former municipal clerk, and so this is the mindset that I'm bringing to this. And enforceability is a colossal issue. And it bothers me to think that I completely appreciate your frustration about analysis paralysis. I completely appreciate it. I think you're right on with that. However, I can't in good conscience present to City Council a change to the law that we know is defective. I mean, that word has been used here tonight. It's defective. That's just, I just can't do it. And yes, the creation of laws or the modification of laws takes a long time, as it should. That's what I think, as it should. So that is, I'm trying to explain my mindset. When I look at it, I think, wow, how are the city administrators going to handle this? And I see a problem right now with that. But I want to thank you, each one of you, for being so passionate about wanting to make this, the application of the Ethics Commission uniform to candidates and political action committees. Thank you.
Commissioner Hernandez?
This is really for Ms. Neiman. Ms. Neiman, in the last election, we had several candidates, it was a big hoopla in the media about some candidates who either they were incumbent or not, but they hadn't paid certain tickets for parking or whatever it was. And I think the city resolved that. I don't know what all the process entailed, but when you mentioned that you would look to see what other cities are doing, perhaps we may look internally and see what we do, what the city of El Paso does, when one of its city representatives runs afoul of the law, and what actions they can take against him or her for that specific violation and how it's resolved. That may be one way of looking at how we're going to approach this.
Yes, sir. That's certainly something that we can look at.
Okay, well then, you have not made a motion. You asked us to discuss this issue. I do want to recognize Commissioner Momsen's institutional knowledge, because she, more than anybody on this commission, has the most experience working inside the city, which is why I value everything that she says about process so much. So, but I also appreciate what Commissioner Kern has said, and I think that we can strike a balance. And so what I'd like to do is to ask our city attorney to do what she's already promised to do, which is to bring us the best information she can, and then we'll just ask her to give us what she's recommended, which is a comprehensive view or a recommendation about where the language needs to be made consistent with what we're looking at. And then we can set the goal of taking action about the information she gives us so that we can send this chunk of what we'd like forward to City Council, okay? And I appreciate your input. I also personally don't like analysis paralysis. I like to see things get done. People that know me know that I like to get things done. I don't like people wasting people's time. But it's important to do things right the first time. They say you measure twice and you cut once, right? Okay. So then you do not have a motion because your second was based on the assumption that Commissioner Woodcraft has made a motion, but he has not made a motion. Are you making a motion at this time, Vice Chair?
Well, let me add a couple comments
Sure.
while I'm thinking about that. What Commissioner Momsen has suggested is a brand-new section to this ordinance. It doesn't fit anywhere in here that I'm seeing. I think you would agree with that. And so, and that is going to be a long discussion. And so I would like to see this 2-year statute of limitations get put on the books right away, because I think that's important for the reasons Commissioner Bray identified, and I identified as well. So, and I'm not seeing any reason we couldn't do that. These are all very simple changes. And then come back and work real hard on the new section to this.
Okay, well, and then I'm going to ask this to the entire commission. Do you think that it's necessary for us to see the amended language before we vote on just amending it and sending that portion to City Council?
Mr. Chair, if I understand the discussion properly, the 2-year statute of limitations already exist in the charter. We're just making it a little easier to read for your average citizen that doesn't understand some of the terminology or lingo in the way that it's laid out.
That's correct.
So if that is the case, I would recommend not pushing this forward because that statute of limitation already exists, and we're currently using the city attorney and the city clerk's office to kind of help mitigate some of that already. Now, if I'm mistaken.
So the
Yeah,
discussion,
I respectfully disagree.
right.
And I'm happy to clarify. I am not reading a 2-year statute of limitations in this. And we went over that and we looked at the longer ordinance. We've looked at this. It's very ambiguous. And as I said, ambiguities are what gets litigated. And, you know, if you have an aggressive citizen wanting to make a complaint, which is their right, and they're past 2 years, there's nothing in here that's going to clearly stop them from making a complaint after 2 years. If the city says, well, no, that's not how we interpret the regulation or the ordinance, which they will, you know, that citizen's attorney, if they have one, is going to say, well, we interpret it differently. We don't see any clear language in here. And then that gets pushed up. and that becomes a litigation matter. I've seen that happen, so I don't think we're talking about, abstract possibilities here. That can really occur. Also, I thought Commissioner Bray's suggestion was very good, because even if we were all in agreement that there's a 2-year statute embedded in here somewhere, and we're not in agreement, because I don't agree with that. But even if we were, the average citizen isn't going to read this and see that. They're not going to know that, and they could go past that 2 years very easily and lose their rights because they're not seeing clear language that says they've got to do this within 2 years. So I think it's important to get that on the books as soon as we can.
Commissioner Hernandez?
Yes. Commissioner Kern, if that's a motion that the language in the area of jurisdiction having to do with the 2-year statute of limitation be included in the section with the filing the complaint, I second your motion.
Okay.
I believe we voted on that already, is that correct? If not, then we'll just.
We did vote
We
on it.
already approved
but-
that.
But
So-
I think Commissioner Hernandez was kind of clarifying what I said, which is, this is standalone. It's very standalone.
Okay.
And it's very simple, and so it's easy to push this forward.
Then let's,
Um,
go ahead.
And I'm not in any way suggesting, Commissioner Momsen, that we don't come back to your very important suggestions, because they are very important. But I just see that we could take that up as a separate topic and should.
Okay, Commissioner Woodcroft?
Last one, Mr. Chair, I promise. I completely agree with you, Commissioner Kern. I'm with you. From an average citizen's perspective, when I read 2 years of the complaint being filed, I assume it's 2 years from when I filed the complaint, not the incident occurred.
Right.
So I appreciate that clarification. I'm not disagreeing with that.
Right.
I think in the conversation with the city attorney, I was led to believe that that also included the 2-year statute of limitations. So I completely agree that if that's not implicit, then I think we should move forward with that.
Okay.
And then revisit the concerns that Ms. Momsen shared as far as an enforceability perspective for candidates and political committees as well.
Right, and they're not
Okay.
mutually exclusive, which is what our vice chair has said. We can ask city council to approve this and not worry about the enforceability issues that are tied up with the other language that we discussed today. So are you making a motion?
Yes, I made a motion, Commissioner Hernandez seconded it.
Is that motion, just so that we're clear, to refer that amendment now to city council?
Yes, what we did tonight.
Even though we have not seen the red line language, it's just clear from our conversation, we trust the city attorney
Well,
can
I've
put
written
that-
out the language. I'll be happy to give it to,
Okay.
Can we have, and I really appreciate the work that the commission is doing, but I would just, either we get like a different set of directions from the chair and the commission about how you all want to tackle the ethics commission, because the posting language for today's item was very specific about making amendments to include political action committees and candidates on this amendment. I think that it's the same provision that Commissioner Kern was discussing, where he saw the language about within 2 years. So while we've notified the public that we're talking about
Right.
jurisdiction for purposes of who is within the jurisdiction of the committee, the conversation that you all had about the 2-year statute has gone beyond what the notice of this was. So for purposes of us having a conversation, I would propose that I come back with a red line that includes the 2-year statute of limitation and the complaint process, and then a fee structure all together at once. Because I would have not notified the public that this commission agreed that it was just about jurisdiction, 2-year statute of limitations going to the council. So the other thing that I would recommend is, and I really do appreciate the amount of time and effort that you all are taking, but prior commissions, and Mr. Weston and I did spend 18 months rewriting the ordinance as it exists here today with the intent, because before, you had to read 5 different sections of the ethics ordinance to figure out how to file an ethics complaint. And I could show you the work that we did in regards to the length and the time and the process that was required prior to this rewrite. So we did go through great lengths to get it to a more clear and succinct, and that as you read the ordinance, you understood the process as you're reading it through. But what I would recommend is that I don't move forward with just a jurisdictional amendment to the commission, to the council,
So I'd like to
for
address.
purposes of notice.
Thank you. The city attorney has raised a very important issue that I have overlooked, and I apologize. We have to follow the Open Meetings Act, and so that means we have to publish our actions, what we intend to do before we take them. And so that objection is not substantive against your amendment, it's just that we need to give the public notice. So we need to move this recommendation to take
Well,
action
yeah.
on it
Yeah,
to the
I-
next meeting. We're sorry about that.
It's okay, I just want
And so
to,
she's keeping us from getting in trouble.
Right.
Thank
Um,
you for doing that.
We could theoretically approve it. Well, we already have
We have-
approved
we
it.
have approved
We already have approved it. So the city attorney makes a very good point.
Yeah.
And reading the notice, she's correct. It's very limited. Maybe that's a lesson for the future, where when we do these agendas for, public consumption, we make them a little broader, so we have a little more flexibility about
You got
what we
it.
can do
I'll make sure that it's broader.
during the
We-
meetings.
We still have to give
But
them,
the way this was submitted, it's
Ah.
very specific
yeah.
about municipal candidates and political committees, and doesn't really give us any leeway.
That's
So
okay. We will work on
I think I
making
have
it
to
more-
agree with the city attorney on this.
Thank you. Okay, so as your chair, you have my word that we'll put it on the agenda and the public will be notified and we'll move swiftly on those issues. So then would you like to withdraw your motion so that we can move forward, since we can't take an action on something that hasn't been published before the public?
I'm not sure it's really necessary to withdraw it. If it is, I do, but I don't think it is.
Okay,
Yeah.
we can table it. Would you like to table?
Yeah, let's table it.
Okay, so there's been a
Yeah.
motion to table the motion, and all those in favor say aye? Aye. Okay, and so we'll take care of it at the next meeting. We have something to do. All right, so that's the next item on the agenda that we have is, we were gonna do a training and presentation, but it's already pretty late. So I would like to entertain a motion for us to table the ex parte communications. And let me explain why. I brought it on the agenda in the first place. This is the section in our ethics code that I think is the most confusing for me. And if it's confusing for me, it's probably confusing for other people. But I need to be able to know what kind of communication we can have with one another and what kind of communication we can have with the city attorney. And we don't want to get in trouble for violations of ex parte communication, so I just thought that a presentation from the city attorney that explains the section to us would be beneficial. But I know that it's late, because we did spend a lot of time talking about the issues that were on our agenda first and that matter. But if you all are willing to have a discussion about ex parte communications before we leave, then I think that would be beneficial, but it's totally okay if you don't. We can put it on to the next meeting agenda, but I just think this is an important conversation to have, so is there?
Let's do it.
All right, there's a
Yeah,
recommend.
I agree.
So-
This is a very short,
Yes, very short.
very short PowerPoint.
All right,
Let's
so
knock
then
it out.
we have agreed to proceed forward with our, and thank you for, because you're a volunteer commission, for allowing us to discuss this with their city attorney. I'm gonna give the floor to our city attorney so that she can talk to us about ex parte communication.
thank you.
You're welcome.
Can I pull up the presentation on this? Thank you. Okay, so you have a printed version of this document. So here is the ethics ordinance and the code of conduct. So within the framework of the ethics ordinance, we subsume also the code of conduct. Our discussion, and Mr. Weston and I have discussed having, at the April meeting per your ethics ordinance, you're supposed to have an annual meeting at some point after April. We could do it in April, where we'll come in and do an entire training on the ethics ordinance, the entire regulatory scheme and how it applies, and then also do a code of conduct training. The code of conduct has 5 pillars that we always rely on, so it's complying with the law and city policy. You make decisions on and act on facts. You never disclose confidential information, you respect the city process, and you maintain a positive work environment. So ex parte communications are found within our ethics ordinance, and it's a specific definition. It means communication made at the time other than during a public meeting of the Ethics Review Commission, a commission panel, or a city council, or the city council, excluding documents or information submitted pursuant to the requirements of this chapter, and any other correspondence or other communication sent to the city attorney. Allowed communications, and I don't want it to be so, this definition is not intended to be so restrictive that the members of the commission or members of this organization are not allowed to call or speak to the city attorney, right? It is intended to be used at the time when we know that there is an item that is coming before the commission that you all will be deliberating on in regards to an ethics complaint. So we have an ethics complaint filed, and then this is when we need to be more cognizant about who am I speaking to and about what in regards to this ethics complaints coming forward. So the allowed communication under section 2.92180 of the El Paso City Code specifically delineates the communications when it's a filed ethics complaint. So what it permits the city attorney's office to do is to confer with the chair and the members of the Ethics Review Commission on procedural matters regarding the complaint, and those are not considered ex parte communications. So for example, there's an ethics complaint filed and we notify all of the commission. There's an ethics complaint that's been filed, we forward it to you and notify you. This is going to be placed at the next ethics commission meeting. You are permitted to call and talk to me about what is going to happen in terms of the process. We would not get into the provisions about the actual substance of the ethics complaint, but for you all to say, what's the next step? What are we gonna do? Things of that sort. What do I need to do to prepare? Right? We're talking about the process. We're not talking about the substance of the actual complaint that was coming before the commission. So this is what is an unlawful ex parte communication. It's specifically directing, it's a direct or indirect communication about the subject matter. So it was what I was just speaking to, right? The subject matter or the merits of a complaint between the complainant and the respondent or any person acting on their behalf and a member of the Ethics Review Commission, a member of the City Council, or any known witnesses to the complaint. So what would be inappropriate is for you to receive a phone call from the complainant or the respondent or any other person that represents those two folks and say, I want to talk to you about the ethics complaint that's coming before you. Like that is an inappropriate discussion that you should not be having with a complainant or the respondent about the merits or the substance of the complaint itself. And then specifically, and you'll find this also and you have the provisions in the file folder that Ms. Lozano provided to you. It's specifically 2.92.180.82 that specifically states it's specifically unlawful for a member of the Ethics Review Commission to knowingly entertain an ex parte communication, as those are stated in the previous discussions I just explained to you before, or to communicate about any issue of fact or law relating to the complaint, directly or indirectly with any other person other than a member of the Ethics Review Commission. So you should not be purposely knowing this person's calling me and talking to me about it and then continuing to have the discussion. What I would advise you is that you need to tell them, I am a member of the Ethics Commission. This item is coming before the Ethics Commission, and it would be inappropriate and unlawful for me to have that discussion, and then you very politely say, I can't have that discussion with you. So that you don't put yourself in a situation where somebody could allege, well, I had the discussion with Commissioner X, Y, and Z about my item, whether they are the respondent or the complainant. And then there is what happens, right? If you are engaged in ex parte communication, you would need to recuse yourself from the proceedings regarding the complaint. So if you were to come and say, look, I happen to be at a social function and complainant or respondent was in the room and they're just going on and on and on about their complaint, and I happen to catch the discussion and make these allegations, I would rather recuse myself. I think that that's more likely to happen where you just are inadvertently put in that position and you're like, whoa, that was not what I was expecting, right? So you would be required to then say, hey, look, I received information and I would like to recuse myself. That's the entirety of the presentation. I don't know if you all have any questions. I think it's pretty straightforward.
Commissioner Woodcraft.
Mrs. Newman, one quick question. Is there a reporting process for, if I receive a phone call from either a complainant or a respondent, I say, hey, we can't talk about that because X, Y, and Z, end conversation. Is there a report process after that one of the commissioners would need to take to say, hey, I received a phone call from X, Y, and Z, here's what we talked about, here's how I reacted? Or how would you suggest moving forward
So
in
the,
that event?
so the Ethics Commission doesn't include that provision. So we did include this provision specifically that would place it on the individual commissioner to then be honest and forthright at the meeting and say, look, I was involved in some sort of discussion and I want to recuse myself. There is no reporting requirement that you would need to then notify me or the chair or any other person that you've had that discussion.
But you're saying that even if it didn't happen, if it was about to happen, you received a call, you stopped it, you're asking if there's a reporting requirement just with that communication, correct?
Yes, sir. If I were to receive a phone call from somebody that wanted to talk about it, and I said, hey, I can't talk about that, I would feel obligated to report that at least to the chair, and it may not be codified, but I would at least like to let somebody know, hey, this attempted communication happened, here's what I did about it, just so there's transparency, specifically with the Ethics Review Commission, because you don't want any cloud, kind of
Right.
shadowing that.
Well, as your chair, I don't see that there's a problem with you doing that. We didn't have an opportunity to introduce you, Commissioner Woodcraft, and I apologize. I'd like to take a moment to do that after this presentation. But for those of us that have gone to law school and we had to take a professional responsibility exam, and of course, our professors often told us the law's requirements for ethics is often much lower than your own ethical standards. And so, you should aspire to do the bare minimum. If you feel like you need to say something, then say it. This clause doesn't restrict that communication from letting me know about that. Is that correct, Mrs. Neiman?
That's correct. It really does behoove the members of the commission to think about holding themselves to a higher standard simply because you're members of the commission. You're not obligated, but that is certainly something that if some of you feel you're obliged, you're required to do that, that's something you could do. But I can't tell you that it happens or that it's happened during the time that I've been on the commission or with this commission, that we have such few ethics complaints come forward that I don't see it becoming an issue.
Well, we're trying to change the
Right.
accessibility of that, but I will say this, that if you feel like you've been engaged or you've been put in a position where you need to declare, just let me know, and then when the issue comes up before the commission, just say that you're recused. I think that we all as peers will respect the fact that you're using your best judgment to recuse yourself. No one's gonna force you to sit on an issue that you yourself believe may put you in an ethical situation. At our very first commission meeting, there was a question, for example, about whether or not I should sit for something because my little brother works for the husband of a complainant. And so there were a lot of different links, but then Commissioner Walker correctly pointed out that even the perception that might in some way affect my judgment would require me to recuse, so I recused. It's just we kind of just move as we go. I think the standard for judges is much higher, but you use your best judgment.
Yes, sir, and I think my question was more directed from it happened. I don't feel like I need to recuse myself, but I wanted to make folks aware that a conversation happened.
And I think that
Very
that's-
circumstantial.
I
right?
think
It's
that's
just like that.
perfectly, I think that that's perfectly acceptable, like protocol, right? That you say, hey, this happened. I don't think that that's outside of the bounds of what this commission could hold itself to.
So,
If I could respond to Commissioner Woodcraft, I think it's a really good idea to report it, or just record it. And, for example, somebody calls you, they want to talk about it, and let's say the conversation lasts 10 seconds. I would include that in my report. I told them I couldn't talk about it. We hung up, it was 10 seconds. Just so that that person doesn't come back later and present a different picture of what occurred that's, not what really happened. So I think it's a good idea to do that. I would do it if I got a call. Another thing I wanted to mention is that I think technically, and City Attorney Neiman can correct me if I'm wrong about this, I think technically you could talk to somebody about procedural things. If they called saying, where's the meeting, what time's the meeting, what do I have to bring? you could talk to them about that. However, I wouldn't, because I think then you get into a gray area. And again, they may interpret the conversation differently than you. I think the safest thing is don't talk to them at all, and that's what I would do.
Or they could direct them to the city to get that
Right.
information. There's a website, and you can call the clerk. So I guess, because thank you for making the presentation, Mrs. Neiman, but just so that I'm clear. So we're not allowed to talk to one another about the substance of anything that's on the agenda, is that correct?
No, I wouldn't say that you're not allowed to talk about substance on the agenda. It's specific to ethics complaints.
Well, I mean, ethics complaints.
No,
No.
you're not prohibited from talking about, what I would caution you is, you have the Texas Open Meetings Act that says you should have the discussions and open in this setting when we're gonna have talking about this commission making decisions. It doesn't prohibit you from talking to one or two of your colleagues about the items that are on the agenda. For example, if the members of the commission call you and ask you about the items on the agenda, you could very well talk to them. But for purposes of ex parte communications, it's specific to a matter that you are going to be deliberating on and making a final decision on, which within the Ethics Commission ordinance, it is ethics complaints.
Right.
So in those instances, I would encourage you all to not have discussions with members outside and then with each other, because you need to be able to come in as a neutral fact finder and then hear the facts as they're presented during an ethics complaint hearing.
That's how I understood it, and I just want to make sure that's, so I can't call our vice chair and say, hey, like,
Well, that's a
so-and-so's
good
on the agenda, and
clarification.
this is how I
agree.
feel about
Yeah.
it. We're not having that conversation, right?
Right, and
That's-
then it also
okay.
needs to be kept clear. Go ahead.
No, I think that what I was going to add is, we were able to go through the last ethics case, and the commission was able to come to a decision on that in one setting.
Mhm.
So there may be a time where you're not going to be able to do that in one sitting, and it may go through the course of maybe more than one sitting. So in between, you don't want to have any of those discussions either. So it all should be, I think the best rule of thumb is, if you're talking about a case as commission members, it should be within this setting to actually get into the details and discuss it. Otherwise, you're not talking about it,
Right.
period. In
So-
between, nothing, other than what's done in here.
And so that's why I wanted to have this presentation, because it is an important section. Are there any questions for our city attorney or comments about this part of our presentation?
Just that I'm looking forward to the training, so we know kind of a little bit
Yes.
more about the ordinance. And so-
Absolutely.
So, yeah, thank you for doing that.
Regarding the training, you said that you'll choose the day where we can go over those issues, like the Open Meetings Act together, or how is that done?
So we'll do, the ethics ordinance calls for an annual meeting to take place after April. So, April's next month. We can prepare to have like an onboarding for the whole board, now that we have everybody. I believe everybody's been reappointed that was due to be expired, and then it would be a good time for everybody to hear the same information. So it would be a training on the ethics ordinance itself, to go through that, doing the code of conduct. And then we could look at your rules of order, which is something that is always instituted at the beginning. So now I think we have a full board, and everybody that's on is scheduled to remain. There aren't going to be any expiring terms now.
We have one question about a commissioner that hasn't been here since our last meeting, Alexandra Serra. What does the commission do when a commissioner doesn't attend meetings regularly or consistently?
So historically, the Ethics Commission staff will reach out to the commissioner and notify, not the commissioner,
City council
the city
representative.
council representative, and notify them that their commissioner has not attended.
Okay, and who generates that communication? Is that Mrs. Lozano, or is that something that the chair needs to do? That's my question.
No, it would either be Colonel Weston or Ms. Lozano that would reach out to the member of the council and notify them that their commissioner hasn't been present.
Okay.
I wanted to let you know that Commissioner Serra, term expired. So I reached out to District 8 so they can submit an appointment.
so we have an explanation for
So
the
hopefully,
absence.
we can get an appointment here quickly so that it's a part of everybody's onboarding.
So once there's a vacancy, it's up to us as staff to stay on that and work with the city council representative to make the appointment.
Thank you for your help. I appreciate it. All right, is there any other question or comment about what we just covered? No? Then at this time, as your chair, I have the authority to adjourn the meeting. That does not require a motion under Robert's Rules of Order.
Mr. Chairman, before you do that, may I just make a general comment?
Yes,
This is for Colonel Kerry Weston. Mr. Weston, we really appreciate your presence here, and I hope that your to-be elevation, to be the interim city manager, does not preclude you from coming to these meetings until that time gets here. I think you add a lot to it, to our commission. I think your participation and your wise thoughts are well received, and we'd like to continue to have them, at least from my vantage point.
Thank you, sir. I appreciate that.
I agree with Commissioner Hernandez, and I've forgotten myself. Commissioner Woodcraft, when we first met, we all introduced ourselves to the public to let them know a little bit about ourselves, who we are, what we do. Would you like to do that? Would you like to introduce yourself?
Mr. Chair, I got to warn you, if you give me a microphone and an audience, I'll take all night. For brevity's sake, I'll keep it short.
You have 2 minutes.
2 minutes it is, yes, sir.
Okay.
Thank you for having me. I'm really excited to be part of this commission. My name is Ryan Woodcraft. A little history, I guess. My wife Jennifer and I moved here in December of 2019. The Army moved me here. We fell in love with the city. I retired, and we're going to stay here for the foreseeable future. We have
awesome.
2 children. Our oldest is 13, very active in sports. Our youngest is 9, also almost 9, very active in sports as well. But 21-year Army veteran, just retired last year. I currently work as a contractor on Fort Bliss. I think, Mr. Bray, actually, sort of worked with you at one point, although COVID kind of shut us down for a while. In District 5, we live out by Pebble Hills High School, so very expanding part of the city, with a lot of challenges that come with that as well. But I am absolutely excited to be here. I'm not a lawyer. I never have been one. I'm just kind of a layman, so I'm getting my feet wet here. But I appreciate the hospitality, and I look forward to working with each of you over the next couple of years.
Well, I want to personally thank you and welcome you to our commission. We're glad that you're here, and your input has been very helpful. So, welcome to the commission, Commissioner Woodcraft. Is there any other comment before I adjourn this meeting? No? Okay, then I am going to adjourn this meeting as your chair, and I'll stay in contact with Colonel Weston and our city attorney, Mrs. Neiman,
Thank you.
so we can set the agenda and do the things that you've asked us to get placed on the agenda for our next meeting in April. Thank you very much, Mr. Weston and Mrs. Neiman. Thank you again for your presentation and for all of your help. All right, have a good evening.
Welcome.